Afternoon, everyone. Good afternoon, everyone. I'm Robin Albert. I'm the Marketing and Training Manager for VMAC. Very happy to have you with us today. We are very happy to be combining forces this afternoon with the Vermont Small Business Law Center. And you are entering Protecting Your Innovations, an essential guide to intellectual property for small businesses. We will be recording the session as we are now, and it will be available later for future viewing consumption, if you would like. You have come in on mute. We would ask you to please stay on mute. If you have a burning question that might not be proprietary to your organization, feel free to come off mute, jump in, or put something in the chat if you'd like. We'll be checking that periodically. And if there's something specific, once we stop the recording at the end, then we can have a more open conversation if you're comfortable with that. I'd like to introduce now the presenter for today, Brian Bailey. Brian is a patent attorney admitted to practice before the U.S. Patent and Trademark Office and admitted to the state bars of Vermont and Indiana. He received a mechanical engineering degree from the University of Illinois and then worked 4 years designing and overseeing construction of automation equipment related to material handling and processing. Brian attended law school at Chicago Kent College of Law during the engineering years and then spent 14 years at law firms working on patents for a wide range of clients in a wide range of industries, including human prosthetics, off-road and recreational vehicles, advanced medical devices, and consumer goods. In June of 2023, he launched a solo practice with a continued focus on patents while also expanding his offerings to include other forms of intellectual property and general business counsel. Brian now serves small to mid-sized businesses and startups and has also been teaching law school courses since 2023, including at Vermont Law and Graduate School. Welcome, everyone. And Brian, I will turn it over to you now. Thank you for being here.
Thanks, Robin. Hello, everybody. So welcome to this VMEX session on protecting your innovations. We're going to talk about intellectual property. So let's get right into it. We've got an hour to cover, a bit less than an hour to cover material that I could spend days on, but we will hit the highlights. And I'm going to save some time at the end for Q&A, as Robin mentioned. So, feel free to bring some questions. So what are we talking about when we're talking about intellectual property? Generally, we're talking about one of these four categories. So patents, trademarks, copyrights, and in some cases, trade secrets, which is a little different than the others, as we'll see. And we're not going to talk a lot about trade secrets other than to mention that they exist. So patents are for stuff, right? They're for devices, processes, new and novel compositions or things. A patent is a form of intellectual property which covers the thing itself and prevents others from making, using, selling that same thing. Trademarks, on the other hand, that's about branding. So there we're talking about words, slogans, logos, things like that. The notion behind trademarks is that we're trying to create a form of intellectual property which indicates the source of the goods or services. So when a business has trademarks, it uses those to sort of provide a shorthand for consumers that when they see the trademark, they know they're getting the good stuff from the business that owns that trademark. We're going to talk more about all this. Copyrights. So that's original works of authorship. Most of us have some familiarity with copyrights. They are automatically created, as we'll see, when the author puts, pen to paper. But it's not just pens and paper. There's lots of different ways that copyrights can arise. It can be things like websites. It can be software and computer code. Really, any kind of original work of authorship or creative expression can give rise to copyright. We'll talk more about all that. Then we've got trade secrets. So trade secrets are, just like the name says, designed to protect information which is kept permanently confidential within the confines of the trade secret owner, right? Usually that's a business. That's a similar sort of subject matter to patents on the other side of the grid here, uh, in that trade secrets can protect the same kinds of processes and methods that patents can cover. Trade secrets can also go a bit beyond that. It can be things like customer lists and business information and kind of how to, which isn't always patentable. But sometimes businesses do have to choose, am I going to keep this thing secret and maintain it as a trade secret, or am I going to go for a patent, which necessarily means I'm going to be showing the public, uh, this invention through the patent process. And we'll talk about that. So, throughout this discussion of these various kinds of intellectual property, there's kind of two ways that businesses could be thinking about IP and what it means for them and for their business. And the way I've broken this out is you could be thinking about, well, it's our IP, right? It's your IP, it belongs to your business, or it's someone else's IP. So when we're thinking about your IP, there we're saying we've got copyrights, trademarks, patents, trade secrets that are attached to our business. And they can enhance the value of the business. They can create assets, right, that the business owns. When we think about intellectual property, it is property. It's a thing which can be bought, sold, licensed, used for leverage. Sometimes patents, for example, are used as security for a loan, things like that. Um, and it develops this sort of tool or maybe weapon, right, for use against copycats. We want to try to prevent others from, uh, knocking off our goods or posing as us out in the marketplace. That's a sort of a trademark issue. So that's IP that attaches to the business, and it can be thought of as an asset, a piece of property, a sort of value enhancer. But then there's also the case of, well, what about the intellectual property of others? And this is about staying out of trouble. So when we think about your IP or the IP for your business, that's about um, potentially making trouble for others. But those same others may have their own intellectual property and they can use it to make trouble for you. And so the other piece that we can sometimes think about in connection with intellectual property is kind of the due diligence side of things. How do we know that we're not going to run afoul of somebody else's intellectual property? So on that side of things, we are thinking about security against unforeseen trouble or expenses, or we've got a new product or a new service or a new brand or something else that we want to develop and we want to gain confidence that the investment isn't going to um, create some kind of problem in the future, right? Before we invest in this new product, maybe we need to know, are we going to be infringing somebody else's patent if we bring this thing to market? Or before we, bring a new line of products on to the market, maybe we need to think about, is the branding we're going to use for this too close to one of our competitors such that we might end up in trouble with their trademarks or copyrights? So we want to avoid being a copycat, even if it's accidental. Accidental infringement of someone else's IP is not generally going to be, um, it's not going to absolve the infringer, right? The infringer still has liability for their infringement. Doing it intentionally can raise the stakes, but accidental is still a big problem. So that's just one of the ways to sort of think about this stuff as we go through it. Okay, so let's start with copyrights, and we're going to move on to trademarks and then patents. I start with copyrights because they are encountered by all of us all the time, everywhere. And um, most businesses are going to have some copyright protection attached to their business. Virtually all, probably. So what's a copyright? Well, it covers the expression of an idea, this creative expression. It does not cover the idea itself. So for coverage of, the idea writ large, that's patent world, and we'll talk about that later. When we think about copyrights, it's creative expressions, right? So for example, in the business context, computer code expressing a business technique, that might be copyrightable, but the underlying data and correlations, that might not be. So what do I mean by that? We can think about something like this dashboard. So the business that creates a dashboard like this one will have started by developing data. They will have found all of this information, the raw information. And then they're going to process that and try to extract some kind of insight from the data that they have. Those insights are transmitted to others by something like a dashboard. And so we look at the graphs and the charts and the different ways that this data is expressed. That creative expression is subject to copyright. So this dashboard here, that could be subject to copyright, where we've taken the raw information and we've processed it into something that's usable by others. And so we've created that creative expression. But the underlying data, that's not copyrightable. So there might be a lot of work involved with developing all that data. Maybe you even needed to generate it yourself. But one of the things we say about copyright is that mere diligence and effort, the sweat of the brow, that's not enough to give the creator copyrights. What they need to do is do something creative with that information, and then it's the creative expression which is protected. So let's talk about infringement, because this is something that people worry about, either because someone else is infringing their copyrights or because they're being accused of infringing someone else's copyrights. So infringement is the term we use for you're in trouble because you copied someone else's material. And infringement is a little bit of a gray area. This is often true with intellectual property, and copyrights are no different. And it has to do with how much of the copyrighted work did you take, the extent of the copying, and how much access to the original copyrighted material did you have. So we sort of think about a sliding scale here. If we can prove that the infringer had lots of access, right? We know that they were looking at the work as they created their version or their copy, then a smaller amount of copying might be enough to get the infringer in trouble. On the other hand, if the copy that the infringer has created is basically verbatim, right? So there's a high level of copying. They basically rip the whole thing off and they're just reusing it without having made any changes. Then we don't really care whether they were looking, it doesn't matter much if they were sort of looking at the copyrighted work as they did this. That sort of gets to this accidental infringement piece that we talked about earlier. So a small amount of access is fine if the copying is significant. And on the other hand, the copy can look a little bit different if we can prove that they based their work on our work. That raises the question of fair use. And a lot of people have heard of this idea around fair use, which is, hey, I'm not in trouble because I've done fair use. Limited copying of copyrighted material, I get to do that. That's fair use. It's protected under the law. And that's true. Fair use is a thing. So examples of fair use copying, I just took a little bit of it. For baseball fans out there, that's like the little snippet of a song played as the batter comes up to the plate, right? We play 5 seconds of a 3-minute song, probably fair use, right? It's 5 seconds. It's not the whole song. So even if we don't have a license for that song to play it as the batter comes up, maybe that's okay because it's just a tiny bit. Or we didn't diminish the commercial value of the original copyrighted work, right? So we're not competing with them. They're out there selling their, record albums. We're just playing 5 seconds of their song. If anything, people are hearing that song and saying, "Ooh, what's that? Maybe I should go find it and buy the album." No diminishment of their commercial value, so fine, right? That could be a fair use. or we're using it for something other than commercial benefit. Classic here is like teaching, right? So um, we we put an image into a slide deck, for example, and we say, look, we're not trying to make any money on this. We're just trying to make our slide deck more interesting. It's not commercial benefit. Maybe that's a fair use argument. We create something brand new out of it. Um, that's the Campbell's soup cans, right? From the Andy Warhol picture of fame, right? So Andy Warhol takes the Campbell's soup cans, turns them into another new work based on this Campbell soup cans, which surely are copyrighted and owned by, the Campbell Soup Company or whoever makes that stuff. But it's a predominantly new work. It's a completely new expression. That can be fair use. Use for education, like I talked about, and critique and satire, always fair game, right? But so fair use sounds great. We'd say, well, we can get out of trouble. We'll just claim fair use. The problem with fair use is that it's case by case. It's a fact-intensive analysis. We're going to look at the alleged infringing work. We're going to look at the copyrighted work, and we're going to sort of run through this whole process and figure out, is this really fair use or isn't it? And there's a whole body of law built up around where the line is. And we can look back at earlier court cases and copyright board decisions to say, yeah, did they cross the line? Did they not cross the line? It's not a place that a business wants to be in, is deciding, are we protected by fair use or aren't we? Because just going through the process of defending on the basis of fair use is sort of fraught with peril. There's a lot of uncertainty there, and it can be expensive to defend. So, not a place that a business wants to be. It's not really a fail-safe insurance policy. The goal is to avoid being accused in the first place when we're thinking about sort of others' IP, right? Um, and it's also the case that if we're thinking about our IP and going after infringers, yeah, they might say, I think it's fair use. And, we would be able to come back and say, well, I don't think it is. So, let's go to the copyright board or a judge and let them decide, which is an expensive proposition. A few other notes on fair use. Just because you're a nonprofit doesn't mean that you get fair use status. Just because the use is internal, that doesn't mean it's fair use. Maybe it means you're not going to get caught, right? Because you're just giving a talk to your employees and using, infringing slide deck images. So maybe you're not going to get caught for that, but it's still copyright infringement. And this is a big one. Content that's freely available on the internet, right? Well, it's right there. It's on the internet. All I had to do was right click and hit save as, and then I can save it, and then I get to use it anywhere I want. Seems free to me. It's not free. That's a classic way to get in trouble with copyright infringement. There actually are sort of trollish outfits out there that are busy sending cease and desist letters with exorbitant amounts of money that they're demanding from copyright infringers on the basis of their putting up an image on their website, which is copyrighted. So that's actually a pretty good way to get in trouble. So how do we manage this situation? We can look to Creative Commons, which is a place where creators can reserve or waive their rights. They can say, I want everyone to be able to use this work. Please, everybody, go use it. So now we're not worried about fair use anymore because the original author has said, no, 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 it's for you. Go ahead, everybody, use it. So the Creative Commons system, and you can look this up, Creative Commons is a thing, it's an organization, provides good stuff, stock images and other material which can be used with, uh, minimal restrictions, and there's no need to individually negotiate with the creator of the work. Same thing as open source. So that's another organization. You can look them up as well. Um, This is especially for things like source code, design documents, like content, as more so than stock images and that sort of thing. Here, there are terms and conditions that are established and communicated by the creator as to the world, where the creator says, yeah, you can use this, and here are my terms. And it's not going to be, you owe me money. It's usually going to be something like, I want attribution or something along those lines. That could be true for Creative Commons too. MIT, right in our neighboring state of Massachusetts, has open source licenses that are really common and are used everywhere. So, right, what are we thinking about with copyright? Who owns it? Uh, the the default on ownership is that the creator owns the copyright. So whoever did the creative work, that individual person, they are the owner. But there are exceptions. So we can have something called a work for hire, where instead of the creator being the owner, it's the person who commissioned the creator to create the work. That person becomes the owner. So when we think about websites, for example, maybe your business hired a website developer to create the website for your business. So that's a classic, hey, creator, I'm commissioning you to make my website. And when you're done, I want to own it, right? I want to own the intellectual property that arises from that website. Websites are totally copyrightable. They're classic creative expressions. So is that a work for hire? Well, yes, it can be, but only if there's a writing that says it is. So the thing about work for hire is we can't come back and say later, well, but I paid you, and so therefore it's a work for hire. Nope, it's got to be a contract. There has to be a writing that says, I'm the commissioner, I'm commissioning you, the creator, to make me this thing, and I will own the copyrights. This is a work for hire. If we have that writing, that contract, then it's a work for hire. If we don't have it, it's not. Another way that we can transfer ownership is just with a simple assignment. So the creator can always say, I own the copyright and I am transferring it to you, right? Because you're going to pay me or you're giving me some other consideration for, for this deal. So assignments can be done after the fact. Okay, so a few just takeaways. When we think about copyrights, what kind of questions should we be asking? First of all, who owns the content that you're distributing? So, if I'm building up a website and I'm grabbing some images or some other materials to use on the website, well, who owns that thing? Did it come from Creative Commons? Have I, you know, complied with whatever the owner wanted me to do? Did I just grab it from wherever? If I just grabbed it from wherever, how did I get it, right? If it's just plucked, we need to figure out who owns that. Otherwise, there could be copyright infringement problems. Um, and if we're thinking about privately owned copyrighted material, then what does the copyright cover and what terms do we need to comply with in order to use it, right? So these are the kinds of things we want to be thinking about. All right, so we're shifting gears. That was copyright. Let's move into trademarks. So like I said at the outset, a trademark is words, names, symbols, devices, which are used to identify and distinguish the goods and services of the owner of the trademark and indicate the source to consumers. So the classic stuff, we see a bunch of here, a bunch below, right? Coca-Cola, Ford, Just Do It, Nike, Advil. These are all highly recognizable and therefore very valuable trademarks. If Chevy wants to make a new model of car and wants to stick a blue oval on the front, good luck with that. They're going to have trouble with Ford. Even if the blue oval doesn't say Ford, right? If Chevy came up with a blue oval that looks just like this and used the same kind of swoopy, lettering, but it says Chevy, probably still have a problem with that because people are going to look at that and say, huh, like that looks like a Ford. Nike, right? If we look at just this little snippet here, there are probably three trademarks inside that little image. One is the word Nike. So, you know, Adidas does not get to say not does not get to use the word Nike on its clothing. Just can't do it, right? It also can't use the little swoosh. That's a trademark. So Nike is the word, the swoosh is a symbol, and just do it. That's a slogan. All three of those are trademarks, different trademarks, all pointing back to the same origin, Nike. So if I want to get, a pair of Nike shoes because the pair I had last time fit my feet just perfectly and it's like Nike is the one that fits me. And I don't want anything other than Nike because they know how to make shoes for me. I get to look for any one of those different trademarks. And when I see it, I know I'm getting shoes from the same company that I got before. So it's all about that source of the goods. It's a shortcut for consumers to find the stuff they're looking for. So how do we get a trademark? Um, there are various ways that trademarks can be rejected. They are not especially hard to get. By the way, copyrights that we just talked about, very easy to register, very DIY-able. Trademarks, somewhat harder to DIY, and part of that is because of this spectrum of distinctiveness. So on the left side of the spectrum is generic trademarks. Those are not registrable. The US Patent and Trademark Office will not let you register a trademark for a generic term. On the other side of the spectrum, arbitrary and fanciful, they're not going to stand in your way, and you can register a trademark for that as long as it's not taken by somebody else already. So let's talk about that. Generic, what does that mean? It's a common name and it can never be a trademark. So I can't have gym bag brand gym bags. I cannot have Apple brand apples. If I go to the trademark office and say, I run orchards and I sell the fruit from the orchards and I want to make it apple, circle R, they're going to say, nope, because you sell apples. That's generic, can't have it. Next up the line is descriptive. So now it's not quite generic. It's moving a little bit further along the spectrum of distinctiveness, and it's going to it's describing something about the goods or services, right? A quality, a characteristic, some feature of it. These can function as trademarks, but they're very hard to get. You essentially need to be able to prove that people, consumers out there do in fact recognize that trademark with your brand. So that's called secondary meaning, and proving it up to the trademark office is not an easy thing to do. Rugged outdoor products is a trademark, and that's a hard one to get. It was gotten by the showing of secondary meaning. Um, but initially, something like that is going to get rejected because rugged sounds like just a feature, a quality, right? The products we make, they're rugged, they're tough. So that doesn't sound like a trademark. It just sounds like a description. That's why it's called descriptive. Chase Bank, by the way, had to fight this out. When we get to suggestive, now we're in the territory of, yeah, you can probably get this trademark. So here, instead of describing a quality, characteristic, or feature, we're just suggesting it. So here, they're registration eligible, no need to show that secondary meaning, no need to fight with the trademark office and do polling and get affidavits from consumers and so forth to show that, yes, in fact, consumers recognize this. You don't have to do any of that. It's registrable. Copper tone suntan lotion is classic here. So copper tone kind of tells you something about what the suntan lotion does. You put it on your skin and then your skin gets a copper tone when you go out in the sun, but it's not describing what the product does. It's sort of suggestive. Okay, and then finally, there's arbitrary and fanciful. So arbitrary is a common word, but in an unfamiliar way or for goods that have nothing to do with the word. So we talked about Apple brand apples, can't have it. Apple brand computers, arbitrary, easy to register that mark. Um, right? Shell gasoline, same thing. And then there's coined terms. So there's no dictionary meaning there, right? We made it up. Xerox, Prozac, all the drugs, right? All the Z's and X's and Y's that we find in drug names. Part of the reason this became part of the kind of culture of the pharmaceutical industry is because they want to, their trademarks and their brandings are extremely important to them. Um, but they don't want someone to spring up and say, wait a minute, I got there, that's my trademark. Like I was doing that first and you owe me, all the money now. So they just make up a name, right? Prozac. You're not going to have a problem with trademarks because you made it up and no one else even heard of that word or didn't exist before. So how do trademarks protect brands? Why do we do this? They protect the brand by discouraging other businesses from adopting or using a logo or a mark or anything else that is confusingly similar. And this is the key sort of standard here, is the likelihood of confusion. So if somebody looks at the alleged infringing materials, right, that have their brand attached to it, and they say, like, boy, that must be from this other brand that I know well. This must be their new thing, and I like that other brand, so I'm going to go ahead and buy it. That would be confusion, right? That's evidence of actual confusion, which shows a likelihood of confusion. So that's the key thing is if we sort of conjure that person and say, you know what, I think they're going to be confused by what you've done here. They're going to think that your goods and services of infringer came from the trademark owner, not from somebody else, then we have infringement. And like I said before, this allows consumers to, it's really a consumer protection um, regime here built up into the intellectual property laws. We're trying to protect consumers and allow them to identify the stuff they want and avoid confusion and make it easy, right? So if it's that Nike shoe that you want, you can find it. You don't have to wade through a bunch of confusingly similar trademarks that make it impossible to actually find the one coming from the brand that makes Nike, right? Nike has its trademarks, they're broadly recognized, and you can't even come close, or there's probably a likelihood of confusion, and Nike's going to shut it down, which means that as consumers, when we see the swoosh, we know it's Nike because no one else uses swoosh on their shoes, even if it's a little different swoosh, right? So what businesses would use these? Well, it's for public facing stuff. It's all about the likelihood of confusion within the minds of the consuming public. And so public facing marketing campaigns are where trademarks matter, right? Stowe, Cabot, Ski Vermont are classic ones that, if we look at Cabot, we see that Cabot with the little image of Vermont behind the B. Um, we know where that came from. That came from Cabot, Cabot, Vermont, the company that makes the cheese, right? So that's public facing. Not usually going to be used for stuff that's internal marketing and activities. All right, we're on time and we've got patents. So copyrights and trademarks attached to most businesses because most businesses have a brand that they care about and most businesses have some kind of creative expression that they're putting out there in the world. Patents aren't for everyone, but for the businesses that need them, they are incredibly powerful because they protect the thing itself. So what does a patent do? It gives the owner of the patent the right to exclude others. So it's an exclusionary right from making, using, selling, offering for sale, or importing whatever goods are covered by that patent. And it can be goods or processes. Both are eligible. And you get that right to exclude others from doing all those things for 20 years from the original filing. As a practical matter, when you file your patent application, it sits in queue for a year to 2 years and then gets picked up by an examiner. Usually there's some negotiation back and forth. So usually it's going to be about 3 years from filing the patent application to hopefully receiving the patent, meaning the enforceable term is about 17 years because it goes back to the original filing. So 17 years of what amounts to a monopoly on whatever the patented goods are. So what aren't patents? They don't give the owner any right to practice the claimed invention, right? This is a common misconception where people say, I've got the patent and therefore I get to make this, or I have regulatory approval or something like that. No, that's not how this works. We're going to talk about, how patents are obtained, but they don't give any affirmative right to do anything. They give the owner the right to exclude others from doing the thing. So no affirmative permission of any kind. And they also don't give any access to government enforcement mechanisms other than the courts and sometimes import authorities. So you don't get to call the police and say, go arrest that guy, he's infringing my patent. That's not how this works. What you do get to do is file a lawsuit in a court and say, Judge, shut down that activity and award me damages because they're infringing my patents. And sometimes you can say, import authorities, those goods coming from that other country infringe my patents, seize them, which actually can be an incredibly powerful tool for patent owners and a relatively inexpensive one to use. But in any case, it is true that enforcement of patents is an expensive proposition. It just inherently is because it requires either a lawsuit or sort of similar litigation style proceedings at the International Trade Commission or Import Authority sort of quasi courts. Okay, so how do you get a patent? What do you need to cover your invention? So, two things. The first is that your invention must be novel. That means that no one has ever done it before. So, um, if your invention was known to the public before you filed your patent application, then it's not novel. And a single, what we call prior art reference, right? So how do we know what came before your patent application? That's the prior art. It's the body of everything that can be shown about the state of knowledge at the time of your application filing. So commonly, that's earlier patents and patent applications, which certainly show, that's what patents applications are all about, is a technical disclosure, which is fixed at a certain, time and which shows the prior art at that time that the inventor thought was their invention. But it can also be things like YouTube videos, scientific white papers. It can be patent applications or other documents from other countries. It's worldwide, it's not just the United States. So the point here is that in order to pass the novelty standard, there has to be nothing in the world that shows that your invention was known to the public before you filed the application. Of course, this can be a little bit of a problem sometimes for patent applicants because they don't know what everyone in the world knows or has ever known about their invention. And so one of the pieces of due diligence for deciding whether to file for a patent application is doing some searching to figure out, is my invention novel or isn't it? Funny story about that. But first, let's talk about the second thing you need, the second hurdle you need to clear to get your patent. And that is that not only does it have to be novel, it has to not be obvious. So, in other words, novel means it's never been done before. Not obvious means it's inventive. So, it's kind of an adequate distance beyond or above the state of the art. As a practical matter, the way this shows up is that you get two or sometimes three, four, five, six prior art references, which are all combined, and together they contain the details of your claimed invention. This is what patent lawyers do all day long with patent examiners, is argue with the examiner over what is and is not obvious. Because the examiner comes and says, I've got three references. The base one shows something similar to what you have, but it's not the same, and so you're novel over that base reference. But it's only missing, these two other details. For those, I'm going to bring in references 2 and 3 and say, and those show the details, but don't have all the rest. And I'm going to say it would be obvious to combine those references. So therefore, no patent for you. So obviousness can be a tough hurdle. Like a sort of silly example would be if my invention is novel, or rather, let's pretend that I have an invention that is only made novel because I painted it blue. And there are the same thing is out there in the world, but the other things out there in the world, they're all green or yellow or red, and no one ever made a blue one, and mine is blue. So that's novel. You can't find me a reference anywhere that says that my invention could be painted blue. Okay, great. You cleared your novelty standard. Now tell me, why is it not obvious to paint it blue instead of green or yellow or red? I can bring in a secondary reference that says there's a thing called paint and you can paint things. And there's even one called a blue paint. And if you apply the blue paint to the invention, now it's the same thing, obvious. So, funny story about this, just quickly. This is a good example of this stuff. I had a client that makes um, firefighting equipment, nozzles, things called monitors, which are like truck mounted nozzles that they use to put out fires from a long distance away. And they had, a new cool mechanism for the way that their nozzles would work. And the examiner brought a shower head in as prior art and said, applicant, you don't get your patent because I found all the details in this shower head here. Um, Fair game. What do you know? The shower head had all the same little parts and pieces. It was the same mechanism. And initially, the examiner said, your claim sort of doesn't specify that it's a firefighting nozzle per se. It's just a thing which moves water. And so that's a shower head, and I'm rejecting your claim. And then we could go and say, yeah, okay, well, we'll just amend our claim to say that it's a firefighting nozzle. The examiner can still come back and say, all right, but it's obvious, right? You could have taken that mechanism from the shower head and applied it to a firefighting nozzle, and it's the same thing. So that's the kind of fights you can get into. So what does it take to, okay, so we talked about novelty and non-obviousness. That's not the only stuff the only hurdles that need to be clear. It also has to be patentable subject matter in the first place. That's what you probably more or less think it is. It's processes, machines, articles of manufacture. It can be compositions of matter like, glue or something like that, a new adhesive, or some improvement on those kinds of things. But what it can't be, no living beings, no naturally occurring substances. So some people know, for example, that I think it's aspirin is derived from the bark of a particular tree. Somebody discovered that somewhere along the way. You can't get a patent saying, I claim the tree bark, because that's a naturally occurring substance. You can isolate the material within the tree bark, the aspirin, and say that's the stuff that's alleviating people's pain. And, create that into some sort of powder form or drug and patent that. But you can't get the tree bark itself. Scientific principles, sort of abstractly, those are not patentable. No laws of nature, similarly. No abstract ideas at all. It's for stuff and processes. Okay, so when do we file patents? For anyone on the call who's interested in patents, if you take one thing away from this discussion, this is the thing you should take away. Ideally, a patent is filed before the invention is disclosed. So what does that mean? Disclosed? Um, it's a non-confidential disclosure to another. So that means, how do we know if it's confidential? Classically, we have a non-disclosure agreement in place between us, the inventor, and the recipient of the information. So if we have a non-disclosure agreement signed between us, that means it's confidential. And so we don't have to worry about that disclosure harming our patent rights. If there is no NDA in play, it can still be a confidential disclosure. There can be an understanding of confidentiality between the parties, but that's not a place we like to be, is sort of proving what the other person thought in order to protect our patent rights. We want it to be easy to prove, and one way to make it easy to prove is to have an NDA. So if a patent application is filed for the invention before any non-confidential disclosures to anyone, then patent rights are preserved worldwide, potentially. It gets better, actually, because you can also have disclosed the invention to another non-confidentially and still have a 1 year grace period in some countries, including the United States, also Mexico and Canada. Also a few others, Australia, but only just a very few others. So those countries offer the 1 year grace period for filing an application after a public disclosure of the invention. However, if you're within the grace period and relying on that for US patent rights, and then later you decide, oh, I also need to get a patent in Europe, sorry. Europe doesn't have the grace period, and the fact of the non-confidential disclosure prior to filing means no patent for you. And after the 1 year grace period, no patent anywhere, period, end of story. I've had a lot of people come to me and say, I've got this great invention and I need a patent. And then we start talking about it and they say, well, yeah, I came up with it, 5 years ago, and it took me 2 years to develop it. And then I started making sales uh, around that time. And here we are now, and I need a patent. And, my alarm bells are going off. Oh, you sold it 3 years ago? Yeah, well, that's it. We're done. There's nothing to talk about here. There is no possibility of a patent if it was sold 3 years ago because the sale is a non-confidential disclosure. And actually, sales are kind of special because even confidential sales can start the clock running in the United States, which is, a small detail. The point being, once there's been a disclosure to another who is not under a duty of confidentiality, patent rights are already lost in many parts of the world, and in the United States, the 1 year clock is ticking. And when that clock strikes a year, patent rights are gone. The invention has been dedicated to the public forever. So this is a tough standard, but there are good reasons for it. What we don't want is for someone to create their invention, get out there and market it, and everybody's, you know, learning how to use the thing and so on and so forth. And they're looking to see, is there a patent out there on this? And they say, nope, no patent. I'm going to make a copy. And we're 10 years on or whatever. Then, and then the original inventor says, oh, wait. No, you can't copy that. I'm going to go get a patent now. No, we all get to rely on if the thing is out there in the world and there hasn't been a patent, then we know there won't be a patent, and people can structure their lives around that. Okay, so For the business owners out there, if you are thinking, hey, that's all great, and I need some intellectual property, I don't know where to begin. And by the way, this stuff sounds expensive. We're here to help. That's what the Vermont Small Business Law Center does. So you can fill out this form using the QR code to get some legal help from us. We can do educational consults. It's a 45-minute thing. We can help get you the information that you need for your specific situation, although we can't provide legal advice. However, we can refer you to an attorney for 10 free hours of free legal services, and they can provide legal advice, including doing intellectual property filings or helping the business come up with a tailor-made strategy for the IP that the business needs. So use the QR code, get an educational consult with us, and then we can refer you to an attorney. And by the way, if you already feel like you know all the things you need to know in order to get working with an attorney and you've watched this presentation, we can call that the educational consult, which is usually sort of a gateway to the referral. And we can say, you've already received your education because you came to one of our seminars. We can just refer you straight to an attorney. 4 minutes remaining, Robin. Any questions from the peanut gallery?
Brian, yeah, so you mentioned that trademarks are, I guess, for business protection as well as consumer protection. If you had to, and I understand it's twofold, but if you had to kind of choose one or the other, what would you say the greater purpose is for?
Well, kind of depends on who you ask. I mean, if it's if you're asking a congressperson who's tasked with reforming the trademark laws, for example, they're going to tell you it's about consumer protection. That's the purpose of the law, and that's what we're trying to do here. If you ask a business owner, they're going to say it's about protecting my brands and keeping other people from infringing on my brands. So it does both things. And sort of the consumer protection piece is the reason the law is the way it is. But the brand protection and business protection piece is the reason people participate in the system.
Awesome, thanks.
Other questions?
Thanks very much, Brian. Wondering if you could just take a minute and I know we don't have a long time here. Talk about provisional patents.
Yeah. So provisional patents are placeholders essentially at the patent office. They sit and in pendency for 1 year at the patent office. At the end of the year, a regular utility, what's called a utility application, which is sort of a standard regular patent application that has to be filed based on the provisional. The reason for doing provisional patent applications, there's a couple reasons. One, the standards for creating a provisional application are somewhat lower. They're actually not examined, by anyone. So it's kind of easier to put this together. So the cost can be somewhat less than filing a full utility application. Probably more importantly for a lot of small businesses especially, is that the provisional application gets you a filing and a stake in the ground while the invention might still be in development. So it might be, hey, we've got a really good idea and we're working on it. And we need to go start talking to prototypers and we want to start doing market analysis and we want to maybe put out some information to the public. So those are all public disclosures potentially. And so we say, well, we don't want to kill our patent rights with a public disclosure, but we also are probably going to change this invention as we go. Provisional application, patent rights are secure, and you've got a year during the pendency of that provisional application to add to it. And so you can develop the invention, do your market studies, do your prototyping, do your testing, and then you can add to your patent application at the end of the year and be off to the races at the patent office. All patent rights protected, but you get to add to it. With a regular utility patent application, once you put your stake in the ground and get it off to the races at the patent office, you're in queue for a patent examiner, you actually don't get to add to the application at all. It's sort of fixed in time. You can file a new application to, the new details of the invention as you discover them. But now you've got two applications, two filing fees, potentially two patents, and the costs multiply. So that's a big part of the reason for provisionals, is that you can have that sort of sit there for a year, hold your place, and add to it and develop the invention.
Thank you. And if you're not done with your market testing, tweaking, whatever at the end of the year, what then?
Yeah, this is a thing that patent folks run into a lot, where they say, "Look, I'm not ready. Like it's not done." Well, it doesn't have to. The thing is, the invention doesn't have to be perfect in order to get a patent. But so there's that, right? It doesn't have to have been made, for example. At the end of the year, you got to file your utility application, assuming you want to claim priority back to the provisional. And if you've been doing public disclosures along the way, you're going to want to claim that priority. So, the way this usually works for people is they'll go ahead and do their provisional application. They'll get as far as they can during the year. They'll file their utility application and then keep working on the invention. And as the little bits and pieces of the invention continue to develop, they just file another application. Like a typical invention, if we think about something like a car, for example, right, a really complicated machine, there are thousands of patents in a modern car. And remember, they only last for 20 years. So everything invented from 2005 and earlier, that stuff's all dedicated to the public at this point. And yet there are still thousands of patents attached to a modern car because they're always inventing new bits and pieces. And so they're just constantly refining their invention, right? The F-150 or whatever. And as they make those refinements, they're filing new patent applications.
Gotcha. Thank you very much.
Yeah, you're welcome. Marina, I see we've got a hand up for you.
Yes, I do. Can you speak a little bit, Brian, on what's happening regarding recognizing AI generated works as copyrightable? I think that's something that we're probably going to be dealing with constantly going forward.
Yeah, definitely. Yeah, the AI space is changing intellectual property. That's particularly true for copyrights, where there's a couple issues with copyright. One is, are AI generated works copyrightable? This is a very much an open question. The answer is maybe. They are not copyrightable all by themselves. So you can't give a prompt to ChatGPT to create an image and then take that image and run off to the copyright office and say, "Give me your registration. This is my image," because it's not. Copyright, remember, ownership always attaches to the author. And the courts have found that authors are humans. They must be humans. And so AI generated works are not copyrightable because they are not authored by a human. However, a human can start with an AI generated work and then make changes to it and use it as sort of a basis for their own work, and then get copyright protection for their modified version of what started out as the AI work. How much human interaction is needed? Kind of an open question. Another problem with, or another question mark about AI and copyrights, particularly the large language models like ChatGPT and Claude and the others, they are trained on copyrighted works. And there's a pending lawsuit with New York Times and a whole consortium of different news organizations who are suing the AI large language model creators, saying, "You did not have a license to use our work to create your large language model. You just hoovered up like everything known to people, all the books and all the websites and all the things from the past, and created this potentially ultra profitable thing from it. you can't do that, right? You have to pay us because we're the holders of the copyright. You have to pay all the holders of the copyrights that generated your large language models. That lawsuit remains pending, and we shall see what happens there.
Fascinating. I appreciate. Thank you. Thank you so much. It's really about the of authorship, right?
Yeah, yeah, it's a very much a live space.
Yep.
We're a little over time, but that's okay with me. If anyone else has questions, I'm happy to. An hour is short, so if there's others, we can talk about it.
It flew.
It does. It flies. I told you, Robin. There's no way we're gonna be under time. Overtime is the risk factor here.
You weren't kidding. Brian, thank you so much. As Brian mentioned, he can and will stick around if anybody has any more questions. If not, the previous slide was sincere, and it goes across the board with anything at the Vermont Law School. They do offer free consult and 10 hours of free legal advice. So anybody has anything, please connect with either VMAC or Brian. And we thank you so much for your interest and helping us better educate small businesses and manufacturing businesses in the state of Vermont. And thank you to the students who attended today.
Thanks, Robin. I'll stop recording.